Morning, everyone. Thank you so much for being here. Um, I just want to go over some quick housekeeping. So we want to make sure that we remain on mute throughout the presentation and the conversation. If you have any questions, feel free to drop them in the chat. And we will go ahead and do a question and answer session at the end. But thank you all for being here.
Next slide. Good morning, everyone. My name is Rosa Flores, and I'm the Director of Programs here at the Latino Coalition for a Healthy California. Thank you for joining us so early on a Thursday, whether you're tuning in from home or you're at your office this morning. We're incredibly grateful to have you be part of this critical conversation. It's certainly a topic that has been of importance for us for the last several months, and certainly as we go into the implementation phase. But before we get into those details, I want to share a little bit about LCHC. So the Latino Coalition for a Healthy California was founded over 30 years ago, and we are a Latinx-led statewide policy advocacy organization working on issues of Latinx health equity. So our goal is really to bring the priorities of the health priorities of the Latino health community to the Capitol in conversations with our legislators, and also ensure that legislation and policy that is affecting our communities is thoroughly explained to those directly impacted, which is why we're here. We're a cross-sector coalition of community leaders, advocates, policy advisors, administrators, and clinicians, providers that all believe in protecting Latino health and advancing health equity for everyone, regardless of language you speak, immigration status, health insurance coverage, and so on and so forth. Our work, our approach really focuses in three different prongs, and that is to deliver community-centered programming, to advance different policy and advocate for policies that make sense for our communities, and to work on strategic communication campaigns. So thank you so much for joining us today, and I'll hand it over to Jen to introduce our panelists.
Thank you so much, Rosa. So here today we have 4 individuals that we are so grateful were able to join as panelists. We have Brooke, Executive Director of Elder Law and Disability Rights Center. We also have Andy, who's a Program Manager at the Social Justice Polity Corps. Sorry about that. Andrew, who is a Housing and Homelessness Attorney at Coalition of California Local Rights Organization. And then Angela, who is a Youth Program Manager here at LCHC. So we'll be going over the CARE Act, and then they'll provide some perspective as we move forward. And then as for facilitators, I will be one of your facilitators. My name is Jennifer. I use she, her pronouns, and I am a LCHC Health Justice Fellow under the Programs Department. I'm also a graduate student at UCLA, and I'm studying Health Policy and Management.
Thanks, Jen. And shout out to Jen, who is working on finals this week and also has taken on this, organizing this forum. Again, my name is Rosa Flores. I'm the Director of Programs at LCHC, and my job here is really to oversee the civic engagement portfolio for the organization, making sure that our communities are getting the important information that they need to live long, healthy lives. Next slide.
Okay, so before we hand it over to Andrew, that's going to provide more of the policy around the CARE Act, I'm just going to go over some high-level information about the CARE Act, just to give some perspective. So in January of 2022, Governor Newsom signed the Community Assistance, Recovery, and Empowerment CARE Core into law. The CARE Act is set to provide court-ordered treatment to Californians living with specific medical conditions through a civil court process consisting of care plans that are designed for up to 12 months, according to the California Health and Human Service Agency. The proposed plan also states that participants who do not successfully complete their care plans may, under current law, be hospitalized or referred to conservatorship with a new presumption that no suitable alternatives are available. Currently, Orange, Riverside, San Diego, Glen, Stanislaus, and Tulum counties are roughly 4 months away from being required to implement the CARE Act to comply with the October 1st deadline. In the months that follow, all other counties, including Los Angeles, are expected to embrace the CARE Act by December of 2024. According to the Newsom administration, the court order response can be initiated by family, county, community-based social services, behavioral health providers, and first providers. We believe the policy strips folks of autonomy, fails to address the housing crisis adequately, and will have negative implications for communities of color, unsheltered folks, and people with disabilities. So now we'll be turning it over to Andrew, who's going to go over the policy. And I will stop sharing my screen.
Okay, great. Hi, everybody. My name is Andrew Chen. I am the Housing and Homelessness Staff Attorney at the Coalition of California Welfare Rights Organizations, otherwise known as CCWRO. We are a pretty old nonprofit up here in Sacramento. We've been around for about 30 years, focusing on public benefits and other safety net programs, how they affect people, how we can make them work best for people, and that kind of thing. I am trying to figure out right now where the share screen button is.
You should be able to
Oh,
see.
I see it. It's the glowing green button at the bottom.
Yeah.
Yeah, that makes sense. Okay. So, so I apologize. This is a little text heavy, but so this is a an actual blog post that I put up on our blog. It has the really short and fun title of CCWR homelessnessblog.wordpress.com. But I am going to be posting updates here about the program, what's going on, sort of all throughout. So if you do want, or if you are interested in that, you can read it there. And so I think, one thing that's important to
Andrew?
focus. Yes.
Sorry, really quickly. We're just seeing a Google search screen. So I wonder if you.
Oh, maybe it didn't. Yeah, maybe it didn't go. Okay, is that better? Did that work?
Yep, we can see you.
Okay, great. And so right off the bat, I think one thing that's really important for people to understand is what your rights are. If you or somebody that you care about, it becomes the subject of a CARE Act petition. But before we get there, a quick overview of the way it works. Basically, so CARE Court is a system whereby sort of anybody with a connection to you or the respondent, that is the person who's going to be subject to the care plan, can be essentially somebody can nominate you for care court, and they will submit that to the court. The court will then assess whether or not you are a suitable candidate for that program, and if they deem that you are, they will notify you, and then you will be assigned a court date, and you will have to show up and discuss. So certain things that are important to know. First, you do have a right to counsel. Anybody who is the subject of a care court plan or order has the right to be represented by an attorney at all stages of any proceeding. The second thing to note is that because you do have a right to counsel, that means you don't have to pay for this attorney. So either a legal aid attorney, somebody like me, if you aren't familiar with what that is, it's basically like a public defender, but for non-criminal cases. So, for example, I used to defend people who were at risk of losing their housing, or I used to represent, unhoused folks who, were having trouble with the legal system. And so even though I didn't work for the court, and I didn't work for the government the way that a public defender was, my services were still free. And that'll still be the case for people who are subject to care court orders. And so legal aid attorneys can be appointed to represent you, or a public defender. The next important thing is that you have a right to what the law calls a supporter. So the way that the law defines a supporter, so what's important to know is that it can be anybody. It can be a therapist, it can be a case manager, it can be a family member or a sibling or a friend. They are defined in the law as someone who can provide this kind of assistance to the respondent. So basically, somebody who can offer a flexible and culturally responsive way to maintain autonomy and decision-making authority over their own life. Number two, someone who can strengthen their capacity to engage in and exercise decision-making and prevent or remove the need to use more restrictive protective mechanisms. And three, someone who can assist the respondent with understanding, making, and communicating decisions. One thing that's important to know is that while the law doesn't mention it specifically, it's our belief that the fact that you have the right to a supporter does not mean that you lose the right to other kinds of language access. So that's somebody specifically appointed by the court, somebody who's paid by the court to come in and help translate officially for you. Those rights don't go away. It's important to know that even if you do have somebody who's going to be helping translate for you or helping, understand what the process is, that doesn't limit any of your other rights around language access. You also have additional procedural protections. So basically, you have to be notified of any hearing. You have the right to receive a copy of any court-ordered evaluation. You have a right to be present at the hearing unless you waive that right. So the court can't just hold hearings and other proceedings without you and make decisions without you being there. And then you have a lot of other constitutional rights that are typically guaranteed in these kinds of circumstances. So you have the right to present evidence. You have the right to call witnesses. You have the right to cross-examine those witnesses. You have a right to appeal. And you have a right to be informed of your right to appeal. One thing that's really important, and probably one of the most important things I think that we should take away from who actually applies to care court, or who does care court actually apply to today, is that care court requires what they define as a serious mental disorder. And importantly, that doesn't mean that is a very narrow spectrum of disorders. So example, as you can see here, which I'm going to highlight, these disorders include schizophrenia, bipolar disorder, post-traumatic stress. Specifically, so you're looking at illnesses that have a schizophrenic or a psychotic component. Without that kind of diagnosis, you are not eligible for care court. And so one thing that's going to be really important for us, our community, going forward, is making sure that courts aren't enrolling and subjecting people to care plans who are not actually eligible. So for example, if somebody has a substance abuse disorder, but they do not have a psychotic or schizophrenic diagnosis, they are not eligible. And so it would be wrong and illegal for the court to continue treating them in that way. Let's see, how am I doing for time, Rosa, by the way?
You're good.
Okay, great. So one thing that's important is that criminal defendants have to have their charges dismissed. So in other types of alternative court proceedings, some types of drug courts or veterans courts, the somebody can be referred to those courts out of a criminal hearing, but the underlying charges are not always dismissed unless the person completes the program. One important thing that's different about care court and is going to be important to holding the courts accountable is that the charges have to be dismissed before the person is enrolled in care court. There's no hanging the criminal charges over somebody's head. There's no restarting the criminal proceeding immediately. Like, those charges have to be dismissed. Also, and we're starting to get into the policy and implementation a little bit, and I know that I and the rest of our community is somewhat skeptical of the ability for the counties to implement these things, but it's important to know that this is what the law says, so that when we challenge the way that counties and healthcare providers and other programs are implementing these things, that we know what the law says and what our rights are under the law. So care plans under the law have to be least restrictive means, and the enrollee must be what they call substantially deteriorating. This is one of those really vague terms, which is a reason why we didn't like the law in the first place and thought it was too vague and had the potential to be abused. What's important to know about least restrictive means is that means that any plan that has to be implemented has to have the lightest touch on the person, depending on their capability. For example, if somebody can otherwise hold employment and pay their own rent and maintain their own housing, you can't just skip directly to enrolling that person into inpatient mental health care treatment. The court is required to pick something that's the least restrictive and the least disruptive to their daily life. And the law also says the person has to be substantially deteriorating. Again, this is one of those things there's going to be litigation about, and annoying lawyers like me are going to be suing the court about. But what's important to know there is that if somebody is showing improvement, if somebody has been, doing a lot better over the course of the last few months, they are technically not eligible for a care plan. And so having that kind of information ready to go, having that kind of evidence is going to be really important for families and advocates and other people who are looking to dispute, care court orders that may be served on people. One other important thing is that if you are referred to care court by a first responder, so that can be a county outreach social worker, that can be a police officer, a firefighter, a paramedic. Those people in the petition that they submit to the court have to show that they've had repeated interactions with you or the person who's the subject of the order. So they can't just see somebody off the street, decide, oh, well, that person needs to be in a care plan, and go into court and file a petition, and then suddenly that person, they have to show that they've had repeated interactions. Again, I personally, if I were drafting this, would have made a concrete number of interactions and had a requirement that they document those in a certain way, other than just say, officer, judge, I did do this. But it is there in the law. We are required, the first responders are required to show that they have repeated interactions with the person. Otherwise, they are ineligible for care court. Care court referrals also have to include affidavits from mental health care professionals. So this requires a licensed behavioral health professional to submit an affidavit. So that's just a letter essentially signed under oath that says that what they say is true. And they have to have examined the person within 60 days of the submission of the petition. So about 2 months. They can also say that they made multiple attempts to examine but have not been successful, and they can sort of make a determination. And so that's a little bit of a workaround, which again, if I were drafting the law, I would not have included. But it's important to know that these are your rights. And so if you get a copy of the report back and it doesn't have an affidavit from a mental health professional, that's defective. And you should the case should immediately be dismissed. You also have to show evidence that the person who's subject to the order was detained for a minimum of 2 intensive treatments. Um, so that has a long definition that I'm not going to get into here, which is why I cited to it here instead of putting it in the body of the article. But yeah, so these are involuntary commitments under Welfare and Institution Codes 5250. You may have heard of a 5250 before, an involuntary hold. So you have to demonstrate that the person who's subject to the order has been detained before in that way. One other thing that's really important. So, as we know, there are a lot of busybodies in life, a lot of people who sort of put their nose sometimes in the business that there shouldn't be. And harassing or fraudulent care court petitions are sanctionable. And so that means that if there is a neighbor, if there is an acquaintance or somebody else who keeps submitting petitions on behalf of you or somebody that you know, you do have legal recourse under the law for the court to sanction that person and basically tell them, hey, like, you have to stop doing this or we're going to fine you. And so, I think we've all dealt with, landlords or neighbors, that won't stop filing complaints or something like that. Care court is an avenue for those types of people to basically harass their unhoused neighbors. And so it's important to know that the way the law is written, that there is a way for people to stop that kind of harassment from happening. And last but not least, so what's really important is that respondents cannot be punished with contempt or failure to appear violations. I don't know if anybody here has prior experience going to court, but typically, if you have a court date and you don't show up, the court can issue, it can basically, issue you was basically a ticket for failing to appear. And so that ticket, can have a number of different consequences. At its most severe, you can, be briefly jailed. But usually it's, it's a fine, and it sort of makes you look, it's not a great look in front of the court. And one important thing about these kinds of proceedings is that a respondent cannot be punished for not showing up to court. As we know, people who struggle with the kinds of really severe psychotic and schizophrenic spectrum mental illnesses that are, at play in this kind of law, like I have mental illness, and it's hard enough for me. I have a less severe form of mental illness. It's hard enough for me to sort of keep track of all the things that I want to do during the day. And let alone somebody who's struggling with really severe mental illness, they might not remember that they have a court date. I remember one issue that I saw when I was practicing in LA is that the tickets that the cops would give people with their court dates were written on a really cheap kind of carbon copy paper. And so once somebody folded that up and put it in their pocket, within a couple of days, just having it rub naturally in their wallet or in their pants or their purse, it would be smudged beyond readability. You could not read it at all. And so if you didn't remember what the cop wrote originally, you don't know when you're supposed to show up to go to court. And so what's important to know here is that somebody who's a respondent to care court cannot be punished with contempt of court or a failure to appear violation. And so this is not in the article, but so basically, what will happen after? Well, what happens after somebody is subject to a care plan? Well, basically, there will be a series of hearings, and the court will, allegedly work with the respondent and their supporter and their attorney and county staff to come up with a plan that is appropriate and, like I said before, least restrictive means form of treatment for that person, and then they will supposedly provide services from there. I know one thing that I'm worried about, and that a lot of us are worried about, is that the court is basically going to be writing orders for resources that are not available. So mental health treatment that's not available, housing supply that simply doesn't exist. And that's not a problem that we have solved or that we have an answer for yet. But, the court can write those orders. Importantly, the burden of fulfilling those orders does not necessarily fall on the respondent. It is supposed to fall on the county staff and the other people, the people who the person is being referred to. The court does have the power to sanction the county, to fine the county, to appoint an outside investigator to help implement those plans. It remains to be seen whether courts will avail themselves of that. Courts are not we'll see how strongly some of these judges are willing to take some of these measures. Anyway, so it's a 12-month evaluation window. If at the end of the 12 months, the judge looks at all the prior hearings, looks at the record of what the respondent has done, and deems them to have completed the elements of their plan, they will be released from the plan. If not, the plan can be extended for another 12 months. And after that 12-month period, the court, can sort of look at more serious interventions, including conservatorship and the deprivation of legal rights. So that's sort of a basic overview of the way the process works. I thought it would be good to focus on the substantive defenses, because that's what I think most of us are going to be concerned about for the people in our lives and in our communities. I think Rosa, do we have time for any quick questions? If
Yeah, we're saving questions
for the end.
Yeah.
Okay, got it.
So if anyone has questions, please drop them in the chat, or concerns. I know this is a very complex policy, and for me, when it helps when there are examples of how this looks like in real life. So for that reason, we invited Brooke Weitzman. Brooke, thank you for joining us. Thank you for that overview, Andrew. Again, very complex. There's so many nuances to the policy, and that's what concerns us, right? Things that Andrew mentioned, are enough resources available? Are folks going to be facing punitive action, etc.? So Brooke is the executive director at Elder Law and Disability Rights. And I was incredibly impressed last month, actually, because now we're in June, of the model that is being implemented or drafted for implementation in Orange County. So Brooke, welcome. And if you could share with us your general thoughts on the policy, why it is harmful, and then what's happening in Orange County.
Definitely. Thanks for having me. If you want me to show the chart, I'm not allowed to share the screen yet. So I need access to the screen share. The Elder Law Disability Rights Center got involved with Orange County as Care Court was developing, in part because it affects a lot of our clients. I mean, in part because we had already been working with the court on reshaping what our homeless court program looked like, to get more in line with best practices and really have a program that was driven by providers and not by just kind of a set of requirements that everyone had to meet that no one could ever meet, like get housing. And so in the role that we were already in, we were just in a really good position to partner with the court and the other agencies involved. So you just heard kind of the big picture of this really complicated law with a lot of vague terms, not all of which have funding to actually make them come to fruition. And that are confusing because they don't have clear instructions. And what that means is it's probably going to be different in each of those 7 counties. And that we're going to see kind of as the counties implement in different ways, starting with the most basic thing. So what you heard was there's a right to representation. Well, functionally, what that means is the legal aid providers in that county have almost a first right of refusal, get to determine if they're going to take the contract to be representing people in that court, or if they're going to reject it and leave that to the public defenders. So in Orange County, our legal aides all talked to each other and agreed that we didn't really want to be a part of the care court process, that we didn't think that was an appropriate role for civil legal services, and declined to take the contract. And so that means that here, that appointed attorney is going to be a public defender. In this county, we also already have public defenders appointed in every conservatorship, limited conservatorship, LPS conservatorship. We already have public defenders appointed in these AOT, which is Advanced Outpatient Treatment Program that we have, which is kind of a criminal-related severe mental health treatment program. So our public defender's office fortunately already has a pretty robust unit that does have experience specifically working with mental health related services. But they're still not going to have the experience on all the civil legal services. So there's going to be a lot to learn as it goes and a lot of challenges that come up. But because of kind of the roles of our civil legal services, the position that our court has taken on really embracing one of the things you heard, which is this is not a punitive court, it can't issue punishment, and the way in which our public defender already has pieces in place, I'm hopeful that despite this very vague and confusing law that may or may not have any positives to it, that in Orange County, there will be minimum harm from it, and maybe there will be some good, that our county is really developing a program that prioritizes referrals. And so looking to make sure that they can measure success by connecting people with resources, not by enrolling people in care court. All right, that when they're looking to tell the state what is success and how are they spending the money, that they're really hoping to have a program developed where they can demonstrate success by having resolved the problems with this robust referral system on the front end by telling folks who either don't qualify or even if they had a qualifying medical condition, really hadn't yet been offered the appropriate services or maybe hadn't been offered anything at all. And really kind of pushing all of the folks who might try to refer into the court to get folks connected with the right services, which then goes back to the problem you already heard of, where are those services? So there's a lot. Let me find you the right screen here. All right, so for another kind of example of one of the things that's really unclear so far in the law is you heard about there's a right to a support person. And for people who are connected with friends and family, they can probably select and bring a support person who they trust and know. But for the unhoused community who's maybe less connected with their family, whose friends might not be in a position to come without leaving all of their belongings unattended or missing a job because they're kind of barely surviving themselves, they don't have their own support person to bring. So one of the first questions that came up that's not answered yet in our county, or as far as I know in any county, is where did these support people come from? If it's going to be a nonprofit or another kind of trained organization, who's going to provide them? Is it going to be like CASA, the court-appointed special advocates for children? If so, where are these people and what will they be trained on? So there's kind of a lot of these just like, we won't know until it starts happening questions. One of the reasons why people might choose to enroll is that piece you heard about getting criminal cases dismissed. So even with a court like Orange County that's fully embracing a focus on referrals, that has very clearly stated we are not going to issue warrants if people are issued a court date and they don't show up. It's a voluntary program that they chose not to voluntarily participate in, and there's nothing we can do about it. And we'll say, right, they're saying those things now, it hasn't started, so we'll see in October what happens when it really starts. But despite the fact that it is this voluntary program, that it comes with this kind of risk of if you don't complete the care court, that could be a factor in a future conservatorship proceeding. There is the potential benefit of having the court be able to order the county to provide things, to order insurance providers to provide things. On the other hand, that order might be worth the paper it's written on, right? If the county simply doesn't have the services and the county is a part of the planning with the court, right? All of these partners are working together in the same room. The court knows up front the services aren't there. And so they may not be really in a position to order things they know don't exist or to fine the county for failing to provide things they don't know exist, rather than to just tell the person, hey, sorry, we don't have those services. Or tell the county, hey, here's a list of the needs that you got to find a way to fulfill, or to go back to the state with a list of the needs. But that when everyone's kind of collectively working on this collaborative system, it seems unlikely that the courts are going to start fining the counties for things they don't have when they knew they didn't have them in the first place. But for people who, and kind of similarly on the insurance, right? So the law absolutely says, as you just heard, that the court can order insurance to pay for it. Like I said, if I was an insurance provider and I was told that the court ordered me to pay for something in a case where I'm not a party, I haven't been to court, I have no reason really to listen, I might be like, thanks for the letter. And so we have no idea what insurance providers are going to do if a court orders them to pay for things that they otherwise wouldn't, or to cover, if a person is only qualified for emergency Medicaid and the court orders them to pay for something above and beyond that would fall within general Medicaid. We have no idea what Medicaid is going to do with that order. They might rip it up. They might think they should follow it because it's a court order. They might send their own lawyer in to go say the court has no authority to issue them to pay for things, to order them to pay for things. Even though it's in that law, right? The care plan, if there is a care plan, involves the individual person and their support person in the county. But if they have private insurance, right, that's a whole other bigger question because, people may have private insurance through their family. And who knows what they're going to do if they start getting court orders. So with all, and I'll give you one more of the big unknowns before I jump into kind of the process that we're seeing start to develop in Orange County, which is HIPAA, which is the protections for healthcare information. So as you heard, a lot of the process is dependent upon specific diagnoses, doctors' statements confirming that a person has that diagnosis, that other less restrictive means weren't helpful, or that they weren't willing or able to comply with something on their own. At some point, that means someone has to give the court medical information, which opens a lot of questions about like how and when medical information is shared. These proceedings themselves, so the actual courts, are private because of the medical information. Logistically, that creates a whole other question, right? Because how are our courts going to have the space and the time to have a judge have individual meetings with each person if they start to enroll any volume of people into these programs? Our court is doing it with one judge who will sit in care court once a week. And so there's a limit to how many potential care court hearings he can have when he's going to be sitting once a week in one court. And other days he'll be working on other court calendars. And at the same time, keeping it as, keeping the courtroom empty for that medical information. But when for someone who's unhoused, goes and seeks treatment, assistance from someone who's getting Mental Health Service Act funding, a full service partnership with government funding for severe and persistent mental illness, and they do all their questionnaires and they try to enroll in services, and then something goes wrong, they're not offered housing, or the case manager fails, or for whatever reason, it doesn't work out. Well, they've now shared all that stuff with county healthcare workers. They may or may not have checked a box with a release. So we really don't know kind of where that information sharing piece is going to fall yet, how clear it's going to be to people when they aren't agreeing that information can be shared with the court, and how the county healthcare agencies are going to treat. Certainly our county's healthcare agency is saying they treat HIPAA with the utmost protection, that they're going to be incredibly careful with everyone's sensitive information. They would never share anything without permission. But kind of what is permission and when do they sign and what box do they check can be confusing, especially for someone who's unhoused, especially for someone in mental health crisis who may be filling out a lot of forms and checking a lot of boxes because they've got to share information to get on the housing list, and they've got to share information to get on the shelter wait list, and they've got to share information to get someone to help them with their SSI application. So there's kind of a wide range of what that could mean. So with all of that kind of parade of terribles of where things could go wrong, what seems to be going okay so far in our county is that they really have, and this is all draft. So this is, I spoke with the court about sharing it, and my instruction was just be sure everyone knows this is just a draft. The judicial forms are still being written. The courts are still meeting among all the counties, and all the parties are meeting in our county. But this is kind of what they have drawn out for our county as a starting draft. And as you can see on the side, there's a lot of places along the way where even if a petition is filed, the case might just get dismissed. So it first gets filed, and if they don't allege one of those very limited medical conditions, it just gets dismissed. If they do, when there's kind of the potential that the person could qualify, then there would be this kind of report on potential voluntary engagement, whether or not, and that'd be someone submitting to the court, here's all the things we've done to try and start a voluntary engagement process. And if they can't show that, then it gets dismissed. Then the person, because ours is through the public defender, there's still a question about when and how they get served. In our county, the person, whoever's filed would have to make sure that they actually serve the individual with notice that the case has been filed. We've heard that in some counties, they're actually asking the public defenders to serve their own clients, which seems strange at best. But in our county, whoever the filing party is, at least so far in the process, would have to have at some point served them. So if it appears that there is not voluntary engagement based on the stuff that's been filed, there could be an initial appearance date set. And if the petitioner doesn't show up, it might just get dismissed because it's a voluntary process, and that would be a signal that they chose not to participate. If they do show up, and the public defender at that point will already have reached out to them and be in communication with them, so they could tell the public defender, hey, I want to do this process, but you go to court for me. I don't feel like coming there. The transportation's inconvenient. Or they could come in themselves. They could ask for a ride. Then it would go to the actual hearing on the merits, and that's determining if the person actually qualifies. And again, they might determine based on what the public defender presents that the person doesn't qualify. There's not enough evidence that the county has met all of those kind of steps along the way. But if they do meet the criteria, and if they do show up or send the public defender to represent them, that's when they would get to the place where they actually set out a case management plan. And that's where those kind of services come up, and the county's partnerships with different entities to ensure that they can provide the services. And some of the things that we've already talked about with the lack of services, if someone in our county comes into my office today and says, hey, I would love to get into a 30-day inpatient program for concurrent kind of mental health crisis and substance use disorder, the answer is, well, like, you can call the county and you can get an interview next week, and then a week after that they'll get back to you if you qualify, and then they can get you on a wait list. And if you still want to get into that program and you have found a way to keep in touch with them in a couple of months, then you could definitely get a bed. And so that's very different than, hey, I'm in crisis today, I'd like to get into treatment and services today. So they'll come up with this kind of case plan, but that's going to depend on how this all plays out in terms of what's actually available. And then, best case scenario, the system manages to develop a prioritization to get people who choose to enroll in it into housing. But the practical reality of that is that that there is inadequate housing stock, there is inadequate permanent supportive housing. That is why all of our counties have hundreds or thousands of people kind of living and dying in our streets. And so any prioritization means someone else gets deprioritized, right? That's just a practical reality, is that if we bump certain individuals up on the list, we are bumping other people down on the list because there is a list. And so there's certainly kind of, in the grand scheme of things, a lot of room for debate about whether that's helpful or harmful, about whether, prioritizing people who are already in mental health crisis versus people who are not yet in crisis and maybe could be prevented by having access to housing, or whether we should really be focusing all these resources on just building more housing so we wouldn't have to prioritize different groups of people. But for now, this is what we have. So we get to the case management plan for that small group of people who exit, right? In our court, they're anticipating it being a small enough group that one judge once a week can handle all the hearings, even though they have to be done privately on very short timelines, that they either decide that they, agree on a plan that the individual is okay with and start working on that plan, and then set progress hearings to check in on whether the county is doing the things they're supposed to, whether the person has any other needs, whether the person is attending the meetings that they're supposed to, or the person says, nope, I'm not, I showed up, I engaged in all the hearings, but I'm not happy with the plan, I'm not going to do it. And that's when the court could actually have an actual clinical evaluation to determine with certainty if they don't meet the criteria still, again, a brute to dismiss the case. If they have come in through this point and they do meet the criteria, that's when the court could decide if they wanted to review and do a case plan anyway. But as you can see, as we work down this plan, each step, if the person is not participating because it's a voluntary program, they might just terminate it. Get the 1-year status hearing. If they're not participating, they might just terminate it. If they have participated, then they can either choose to extend for a year if they think that there's a benefit to having the court oversee the services. They can do a graduation, or the court could try to involuntarily reappoint for a year. Although again, if they don't participate in that, it ends up in the may terminate section. All of those things lead to kind of what you heard about briefly from Andrew, which is if a person makes it kind of through all those things, it's determined that this still isn't enough, that they still aren't able to safely care for themselves, that the threat of this being a factor in a conservatorship. But this is another one of those kind of practical reality is different than the paper things. So right now, there are tons of people who actually are unable to care for themselves, who are very low income, have disability or no income, who actually can't meet their daily needs, and who fall well within the current definition for conservatorship of gravely disabled. But the only way they become conserved is if the public guardian actually files. And what we see is the public guardian is so underfunded that in most cases, when there's not an estate, they don't file. And so even for the people who, without the care plan, could be conserved, it is very common for them not to be conserved when we're talking about folks who are currently unhoused, who are living and dying in the streets. It's a little, when people end up in the criminal justice system and then referred into hospitals, they're more likely to get conserved. But for people who are not already in jail, it's hard. Like there are shelters who call me and say, hey, we have, 3 people here who can't care for themselves. We can't throw them out because they can't care for themselves. We can't care for them. What do we do? And the answer is, well, you can call the public guardian, but they're unlikely to file the conservatorship to get that person placed into a facility that can meet their needs. So even if you get through all these steps, and even if there is a kind of greater presumption that you might be conservable, that still would just kick off the public guardian filing a conservatorship proceeding. You would again get appointed a public defender, at least in Orange County, although in other counties that may be different, to defend against the conservatorship proceeding. And they would have to demonstrate that kind of gravely disabled standard that you aren't able to care for yourself. So in the big picture, certainly, all of the problems that you have seen and heard about the law are very real, and there is going to be a lot of confusion with different counties doing different things, and people sometimes cross county lines, and who knows what happens if they move from county to county, if these cases are transferable. But I think specifically the way in which Orange County is developing it, because of the existing homeless outreach court program and the existing the outpatient treatment program, I think Orange County is attempting to develop it really focused on this kind of referral voluntary program and hoping to be a model that we can then ask other counties to turn to and say, look, this law may get voided for vagueness at some point, but between now and then, maybe Orange County is a place you should be looking at as a way that your courts can model it to be less intrusive, more voluntary, more in line with healthcare best practices. All of that subject to them actually starting it. So we see if what happens is what they said.
Thank you, Brooke. I'm furiously jotting down notes, even though I've heard this before, because there's certainly, I think your term parade of terribles is true. There are a lot of gaps in this policy, and we're deeply concerned specifically for folks who are unsheltered and who are and people of color. We have a couple of folks on our call this morning who have a family member who has interacted with the mental health system or have personally been involved with the mental health system, and we wanted to get their perspective on this policy. So Angela Maldonado, who's part of the LCHC team, and Andy Bianchi, part of Social Justice Politicore. Welcome. Can you share with us, just start off by sharing your general thoughts on Care Court?
Hi, everyone. Good morning. My name is Angela. Thank you, Rosa, for the intros. It's scary. I feel like anytime, the justice system is involved, it's another obstacle, it feels like. So yeah, it's just resounding thoughts right now.
Yeah. Andy?
Hi, I'm Andy. I use he, him pronouns, and I work at Social Justice Politicore. My general thoughts are, even if this program is implemented in the most ethical way possible within the confines of what it is, it's still punitive, because there's always the threat that you can have all of your rights taken away, placed somewhere against your will. And I can tell you from personal experience that mental health care providers in crisis situations don't always listen to the people who are experiencing a mental health crisis. So I think I would be highly, highly skeptical that along these points, especially for people who are having like a really severe mental health crisis and are living outside, they're not going to be getting the support they need to succeed. I think this kind of sets people up to fail. And I think it's highly unlikely, considering the shortage of mental health workers we have. Just that by itself, also, we don't have the services and we don't have the housing. But who's going to help people like advocate for themselves? And who's going to help people if they're like, hey, I don't want this. But when the judge has the ability to place them there involuntarily, so that's like a legal decision that's made not by a mental health care provider. The final decision is from the judge. And so that I think is just kind of also like counterintuitive to how you would approach a person who's been traumatized and needs support. Sorry, that was a lot. You asked for like a quick thing and
Oh,
I talked
no.
a lot, but yeah.
You're fine. Yeah. And I know we have a couple of questions that we had drafted for you all. And I'll hand it over to Jen. And then while Jen does that, if I know we're coming up on time here, as you know, it's a lot of information. We understand that. And this is not going to be the last that you hear on the topic, especially as we approach October, December, which is some key benchmark dates. So drop your questions in the chat. I will also share that LCHC, along with other statewide policy advocacy organizations who are part of the Behavioral Health Equity Collaborative, are keeping a pulse on this and organizing to act collectively. So yeah, Jen, I'll hand it over to you for questions.
Thank you. And thank you, Angela and Andy, for sharing your thoughts about the policy. I think you both bring up incredibly valid points, and we appreciate you sharing your perspective and being vulnerable with us here today. As Rosa mentioned, we're going to get into a couple questions. So the first question is for you, Angela. What has been, if you're comfortable sharing, what has been the most difficult part about mediating between mental health and legal systems along with your family?
Yes, thank you for the question. So just to give some story behind that, I was 5 with my brother. He was about 13, 12 when he started developing schizophrenia, and we later got that diagnosis for him. But it took my mom, and she didn't learn English. She didn't know English at that time. So it took my mom having to connect with teachers, principals, the folks that she knew were around my brother and were able to support him, to see what resources were out there for her. And it also took her having to work nights and being up in the morning and having to travel long distances to take my brother to get care. So I have that lived experience through my brother, and thinking that, the court system would be involved in that in some way, just makes me think that, folks in that situation now would probably not get to the place where my brother is now. Thankfully, my brother is about to turn 38 next month, the month after that. And he's now in it's like a shared living situation, and it's a home. So he has his own room. He has his games, which he's always loved. He has like his own clothes. He was always like a Lakers fan. So he has a space to call his own. Unfortunately, it's not with our family because that's not the safe place for him, but it's a place that he's happy and he's able to plan for himself. So my fear is that other families won't get that opportunity for their loved ones. So I'm hoping to continue this conversation in other spaces, and also encouraging the folks here today to connect with your local county to see what the movement is for this policy, to make sure you're involved in these conversations, because it's important right now to get involved in these combos before these things start moving forward. Thank you, Jeff.
Thank you so much, Angela. The next question is for Andy. How does the care court compare to existing carceral system?
Thanks. Can I just quickly ask, is there a time that we're ending that's not 10
We
since
wanted to end at 10, but we can go
okay.
a few minutes over. So we'll probably end at 10:05 if folks are okay. And if folks have to hop off, that's fine. I just know we started a little bit later. So 10:05 is our hard stop.
Okay. I wrote so many things down, but I'm gonna do like just a very brief summary of my thoughts. One thing I wanted to point out is the language for putting someone on an involuntary hold for like a 5150, which I've been put on before, is you have to be a danger to yourself, others, or you gravely disabled. And that's like, so it's happening currently. You are a danger to yourself or others. The thing with the CARE Act is the language says one of the criteria for meeting, like being part of the CARE program, is you would be likely to result, like your condition would be likely to result in those things. So it's not something that's currently happening. You can meet criteria because someone says probably in the future they might be those things, which is wild because that like really widens the net in terms of like how many people you can force into a treatment program against their will for things they haven't done yet or aren't already happening. So I think that feels very like akin to a carceral system to me. And I think any system where you're confining people against their will is inherently carceral. Like, I mean, there are clearly other options, but the thing is, we don't spend money on the other options collectively as a state, cities, counties. We spend $50 billion a year on law enforcement and prisons and policing, and we do not fund the services and the housing that this act is supposed to provide but doesn't mandate and doesn't provide money for. So in that context, it's another system that lets us disappear people we don't want to deal with and we don't want to look at anymore. It's a shortcut. Like, you don't want to see homeless people on the street, let's find a place to shove them. So yeah.
Thank you for that. And it's so interesting that you bring up that point, Angie, because we've been following what's happening in San Francisco, LA, and the rhetoric that a lot of folks in decision-making spaces are adopting is, yeah, we need to clean up these streets. So for you to share that around disappearing people is, I think, on target, and unfortunate that folks are approaching it that way. I want to give space for folks who have questions to drop them in the chat, or you can come off mute too if you don't want to drop them in the chat. If not, then Jen, we can continue with the questions that we had. But I do want to give opportunity before we close out here. Okay, hearing none. I know I've gotten some private messages. Oh yes, go ahead, Sonia.
Hi, thank you so much to everyone for sharing your experiences and for the overview. That was incredibly helpful. I think I have a lot of questions about the process, but given time, I think the main thing that's on my mind is I'm with API Equality LA. We are a mental health advocacy for the queer and trans API community. And I'm wondering, like, what can we do as like a CBO to help the work that y'all are doing? Because this, like, ever since the CARE Court came into being, we've been very concerned about how this is going to impact different QT BIPOC communities. So I'm just wondering, like, what is it that we can do now, and what can we look in the future to, like, how to be engaged with like this work?
On the legal side, which is kind of less immediate, but in the big picture, is definitely exactly what you all are doing, of like organizing community education, making sure you know what's happening. The first attempt to reverse this law, right, went to the Supreme Court, challenging it on its face, and the Supreme Court didn't accept it. And so we'll see if that's, I don't know for sure if that's been refiled at the trial court level or not, but the arguments that were made in that case were about the disparate treatment, were about the racist impact, were about the discrimination. And part of the reason it seems likely that the court didn't look at those issues is because because every county is kind of doing their own thing and the law is kind of vague. we don't have the evidence that those things are happening yet. And so from the legal side, certainly making sure that everyone who is doing work in this area is staying engaged with the community, keeping track of what your county is doing, keeping track of how it's impacting the community that you partner with or are a part of or are serving, to make sure that next time someone challenges the law, if it is having all of those kind of anticipated discriminatory impacts, that we have the individuals who are being harmed by it who want to challenge it.
Any additional comments on that question? What CBOs can do? Okay. Well, we're coming up on time, and I will have folks, if panelists, if you all feel comfortable sharing your contact information in the chat for anyone that might want to follow up with you, that's great. There's no pressure to share contact information. I'm sure your inbox are inundated. You can always reach out to LCHC. And Jen, if you could share our screen with that contact information, that would be great. Or maybe not. Jen, can you hear me? Okay, we will also share the slide deck, which has the names and our contact information with all the folks who registered for this webinar. Again, this is only part of the advocacy that we're doing around the issue. We have to keep our eyes on the ball and make sure that we're doing what we can in terms of organizing. So thank you once again to our panelists, Andrew, Brooke, Angela, and Andy. We appreciate you so much, and I hope everyone has a great day.
Thanks, everyone. Take care.